is beyond judicial review. The unelected, black-robed, tyrannical, inferior district trial court judges literally have no power here. They have no authority at all. The bonus show. So glad you could all join me for this. We're going to cover that concurrence from yesterday's Ninth Circuit Court of Appeals win for Trump on his activation of the Oregon National Guard into Portland to protect federal personnel and property of that ICE facility. And this concurrence is really exciting because not only did Trump win, the restraining order from the unelected black-robed tyrannical inferior district court judge Karin Immergut got thrown out. But in this concurrence, which doesn't have precedential authority, but it's a good roadmap for the federal courts, Judge Ryan Nelson argues not only does he agree with the outcome, not only does he agree that Trump had statutory authority to call out the National Guard in Oregon, he also argues that the federal courts, including him, a federal judge, simply lacks the authority to second-guess the president's decision to call out the National Guard. It's not reviewable by the federal courts, period. Judge Ryan Nelson, by the way, just like Judge Bade and Nelson were the majority here. Both of them are Trump appointees. All right, Judge Nelson. I concur in the order that concludes Trump is likely to win on the merits in his assessment that there's a colorable assessment of the facts and law to sustain his 12406-3 activation of the Oregon National Guard. Normally, that would be enough, just declaring the winner. But given that these legal issues are moving quickly, I write separately to emphasize 4 points. First, under current Supreme Court precedent, presidential determinations under 12406 are simply not reviewable by the federal courts. Second, the plaintiffs here, Oregon and Portland, have serious standing issues because they're seeking injunctive relief, a TRO, that this court lacks the power to issue. And they don't have an actual injury. Now, federal courts are supposed to hear controversies and cases before them where people have suffered an actual injury. Oregon and Portland have not suffered any actual injury by Trump's activation of the Oregon National Guard. They're merely afraid that they might suffer an injury. Third, while the order takes a more fact-bound approach to the issues presented, the president's determinations under 406-3, unable to carry out the laws of the federal government with the regular forces, and 12062, rebellion or danger of rebellion, are bolstered by the history and tradition of the early Militia Acts. And fourth, the likely lawfulness of the president's determination under 12406 is bolstered by his proportionate response to the events in Portland. In other words, he only called out a few hundred National Guard, not a few thousand National Guard. Nelson writes, we held in the earlier Court of Appeals case for Trump, the California National Guard case, we held in Newsom versus Trump that the presidential determinations under 12406 are reviewable. Again, that was a different three-judge panel of the Court of Appeals in the Ninth Circuit. Similarly, because Newsom proceeded to a likelihood of success on the merits, it implicitly found standing for the state plaintiffs in that case, California and Los Angeles. It likely got both of those issues wrong. As a matter of first principles, I doubt that this three-judge panel, is bound by Newsom, the prior three-judge panel. We have previously held that a published opinion, even at a preliminary injunction stage, does bind future three-judge panels on pure issues of law, but we've never held that an order granting a stay pending appeal of a TRO binds future three-judge panels even on pure issues of law. And it would be odd if the Newsom merits panel would be bound by its initial conclusions made during the truncated stay pending appeals. In other words, TROs are issued when there's very little development of the evidence. It's a preliminary action. A judge can make preliminary findings and then change its conclusion once the evidence is more developed. That's a court. So Judge Karin Immergut, by herself, could come to one conclusion at the preliminary stage. She's not bound by that. If more evidence developed, she's entitled to change her mind. If that's true, if Karin Immergut would be entitled to change her mind, why would that preliminary finding be binding on her bosses, the Court of Appeals, if it's not even binding on her? Similarly, it does not make sense that another panel hearing a stay pending appeal on a different TRO should be bound by the earlier Newsom decision. That legal nuance, however, can wait to be decided. As Trump requests at this stage, we follow the holdings in Newsom. So Trump also disagrees with Newsom. But what Trump said going into this case was, listen, we disagree with Newsom. We think it's bad law. But even by that bad law, we still believe we win. So go ahead and we won't argue that bad law issue now. Go ahead and apply what we think is bad law because we win anyway. And in fact, they did win anyway. But Judge Nelson says still, current Supreme Court precedent dictates that Newsom, the earlier decision, was wrong to hold that the president's determinations under 12406 are in any way reviewable by the federal courts. Trump's argument that 12406 may not be reviewed by the federal courts tracks Supreme Court case law precedent. The government rests its argument on Martin v. Mott and Luther v. Borden. I think he explains these, so I'm not going to go into detail on this. Under those two cases, whether the president has lawfully invoked 12406 presents a political question the courts cannot review. Remember, of our three branches of government, two of them are political. Article 1, legislative branch, is political. Article 2, executive branch, is political. That's why they're elected. The Article 3, judicial branch, is not elected. They have lifetime appointments because we separate them from being immediately accountable to the American body politic by having to run for election repeatedly, because they're supposed to be an apolitical branch of government. If there's a political policy question to be made, it's for Article 1 and Article 2, not for Article 3 judges. The Martin case from the Supreme Court arose in the wake of the War of 1812 when President Madison invoked the Militia Act of 1795. Congress enacted the 1795 Militia Act pursuant to its power to call forth the militia to provide the men necessary to defend the nation from British invasion. Madison directed the governor of New York to raise a militia. Mott, a private in the New York militia, refused orders to assemble, was court-martialed, found guilty of refusing to enter service. He appealed, and the Supreme Court of the state of New York granted him relief. Said, yeah, you don't have to respond. It concluded that President Madison had not properly adjudged that there was an invasion or imminent danger of invasion. In other words, the Supreme Court of the state of New York second-guessed the Article 2 executive branch president on the need to call up the National Guard. The case reached the Supreme Court of the U.S., and Justice Story, one of the most famous justices on the Supreme Court in its history, Justice Story reversed the lower court. He explained that the authority to decide whether the exigency had arisen, the circumstance had arisen to call forth the National Guard, belongs exclusively to the president, and that his decision is conclusive upon all other persons. And then in a later case, Luther, also interpreting the 1975 Militia Act, Chief Justice Taney, writing for the Supreme Court, held that the power of deciding whether an exigency has arisen is given to the president. The Supreme Court thus twice held that the 1795 Militia Act, and by extension, Statute 12406, which uses similar language and is a successor of that act, is unreviewable by the federal courts. The Supreme Court has said in our constitutional structure the safeguards to guard against usurpation or wanton tyranny through the militia acts is the frequency of elections and the watchfulness of the representatives of the nation. In other words, the political process, not the judicial process. Reasonable minds will disagree about the propriety of the president's National Guard deployment in Portland, but federal courts are not the panacea to cure that disagreement. The political process is. Further cementing the lack of judicial review, plaintiff Oregon, and Portland seek to enjoin federalization and deployment of National Guardsmen through non-statutory ultra vires review. But the Supreme Court has held that such review applies only when an agency has taken action entirely in excess of its delegated powers and contrary to a specific prohibition in a statute. No such specific prohibition exists within 1206. So Martin, the Supreme Court decision, Luther, the Supreme Court decision, and the limits the Supreme Court has placed on ultra vires review all counsel towards us, the federal courts, lacking the power to engage in judicial review. The prior Ninth Circuit Court of Appeals decision of Newsom distinguished Martin and Luther, meaning said they don't really apply to this case, in part by relying on a different Supreme Court decision, Sterling. But Sterling dealt only with a governor of a state, not the president of the United States. This gets a little nuts and bolts. I think I may skip the details of the Sterling decision. He just concludes Newsom commits error by relying on Sterling rather than on Martin and Luther, both of which hold the president invokes the 1795 Militia Act or its eventual successor, 12406. If the president does that, the decision is unreviewable by the federal courts. One could qualify these cases. Justice Story observed in Martin that this awesome presidential power was meant to apply during sudden emergencies, upon great occasions of state, and under circumstances which may be vital to the existence of the Union. The War of 1812 was such a time when the existence of the American Union was at stake. Congress had explicitly declared war, and any argument that the U.S. was not being invaded was implausible. And Luther arose out of an outright civil war taking place in Rhode Island, the Dorr Rebellion. The Dorr Rebellion arose in 1841 because, unlike the other states, Rhode Island did not adopt a new state constitution during the American Revolution and operated instead under the colonial charter granted by King Charles II in the 1660s. Civil war broke out when dissatisfied citizens tried to hold their own constitutional convention, creating a new state constitution to extend the right of suffrage to a greater portion of the population. Those citizens took up arms against the charter government, claiming that they were the rightful new state government. Both Martin and Luther could be cabined to distinguish from the events here. Though both cases and the events in Portland represent threats to domestic tranquility, Martin and Luther interpreted the 1795 Act in the context of existential threats to the Union, in the case of Martin, and outright civil war in a state, in the case of Luther. The situation in Portland involves violent protesters preventing the federal government from executing the laws of the U.S. around one localized federal building with regular forces. Ultimately, Martin and Luther categorically held that the president's decision in this area is absolute as a circuit court of appeals. Even if recent Supreme Court jurisprudence has perhaps called into question the continued viability of its precedent, we are bound to follow a controlling Supreme Court precedent until it is explicitly overruled by the Supreme Court. Whether Martin or Luther can be distinguished by Sterling or on other grounds is therefore an issue for the Supreme Court to decide. Until the Supreme Court says otherwise, we are bound to follow its precedent. The state of Oregon and the city of Portland also have serious standing issues that have not been addressed, given the preliminary posture of this case, as they were not addressed in Newsom either. When federal courts have opined on similar issues, the party bringing the lawsuit usually seeks either a remedy at law or habeas relief. A court may incidentally declare that executive branch actions involving the military were illegal in such cases, but a court does so only to grant the plaintiff a remedy at law. Oregon and Portland here bring claims solely for injunctive and declaratory relief, asking us to declare the federalization and deployment of the Oregon National Guard unlawful. Oregon and Portland allege that federalizing the Oregon National Guard was ultra vires, outside the scope of 12406, already decided that it was within the scope of 12406. Prohibited by the Posse Comitatus Act. Nope, they're only protecting federal personnel and property, not doing law enforcement. An infringement on Oregon's police power. No, the federal government has supremacy over the state police power. 4, designed to coerce the city and state to accede to the Trump administration's political prerogatives. Again, the political prerogative here is immigration law. The federal government has supremacy in immigration law. A violation of equal state sovereignty. No, the 10th Amendment says the federal government has the powers delegated to the federal government, and the militia power was delegated to the federal government in the Constitution, to Congress, and then in 12406, Congress delegated that authority to the president. Unlawful administrative action just doesn't apply here. It's not unlawful. It's valid under 12406, is already determined, and contrary to the separation of powers, just nonsense. Some of these claims are bare allegations that the executive, the president, violated the law, which cannot be a standalone basis for an injunction. And the remainder are claims where Oregon and Portland allege injury to sovereign political rights as a state within the Union, like the 10th Amendment claim. But injuries to plaintiffs' sovereign political rights are not enough to confer standing. Federal courts only issue injunctive relief when private rights or private property are infringed, not to protect the rights of sovereignty, of political jurisdiction, of government, of corporate existence as a state, with all its constitutional powers and privileges. We, the Federal Court of Appeals, thus may not be empowered to issue injunctive relief here, meaning the plaintiff's claim lacks redressability. We don't have the authority to give them what they're asking for. Plaintiffs also lack an injury in fact, because all political rights Oregon may have had in the militia were ceded to the federal government during constitutional ratification. The militia cause grants Congress the power to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. U.S. Constitution, Article 1, Section 8, Clause 15. States admitted to the Union after initial ratification, like Oregon, acceded to the Constitution, including the delegation of their powers to the federal government. And Congress enacted 12406 under one of its delegated constitutional powers, the militia power. So an illegal federalization and deployment may cause injury, in fact, against Congress, but not against the states, which lost that power to Congress when they became states. This legal reality, constitutional reality, raises serious issues over the court's ability to proceed to the merits on the claims of Oregon and Portland. The parties have not fully addressed these questions. But before a panel proceeds to the merits, the legal merits on this case, we should assure ourselves that Oregon and Portland have sufficient standing that we can even take on the case in the first place. Assuming the president's determination is reviewable, which Nelson says it's not, it is reinforced by the historical tradition of similar presidential actions. Our conclusion in the majority opinion that the president's determination under 12406(3) is likely lawful is also supported by the historical tradition established by the early Militia Acts. Ultimately, 12406 is part of a statutory lineage stretching back to the Militia Act of 1792, designed to enable one of the core functions of the Constitution, maintaining the integrity of the Union. We must therefore be careful when we interpret statutes part of the lineage of the Militia Act of 1792, all of which enable the president to carry out this solemn constitutional function. It requires special justification found in the statutory text in these types of statutes to narrow their scope from founding era understandings. Otherwise, we can presume that such a provision carries the old soil with it and rely on founding era understandings to determine whether the president lawfully invoked 12406. Therefore, when the president acts within the bounds of this historical tradition, it provides near irrefutable evidence of good faith, lawful action. Indeed, it would satisfy an even less deferential standard to the president than the standard adopted in Newsom, the earlier Court of Appeals case. President Trump's September 28th deployment falls within the history and tradition of the early Militia Acts. Individuals within a group of about 200 people have engaged in violent activity in opposition to a single set of laws that carry out federal immigration enforcement. Rather than try to enact political change through the ballot box, they have assaulted the federal officers in Portland to enforce the laws and other Americans who disagree with them on the wisdom of those laws. They tried to burn down a federal building, forced that building to close for 3 weeks. Sadly, regular law enforcement cannot on their own contain the situation. State and local officials have also made clear they do not support the enforcement of federal immigration law, further impeding the enforcement of federal law. In response, Trump invoked 124063. The situation in Portland echoes the history discussed above, and the federalization and deployment falls within the broad tradition of how the early militia acts were used. The majority opinion, which Nelson joined in, one of the two judges in the 2-1 majority, does not address whether the president likely has authority for National Guard federalization and deployment under 124062 when there is a rebellion or a danger of rebellion. The historical tradition of the early militia acts also supports the president's determination as likely lawful under 124062. The government urged Judge Karin Immergut to construe rebellion as open resistance or opposition to an authority or tradition. On the other hand, Portland and Oregon urged Judge Karin Immergut to define rebellion as open, organized, and armed resistance to an established government or ruler, an organized attempt to change the government or leader of a country, usually through violence. The unelected, black-robed, tyrannical, inferior district trial court judge Karin Immergut adopted an incorrect reading of rebellion, providing 4 criteria. First, this dolt of a judge held that a rebellion must not only be violent, but also armed. Second, she held that a rebellion must be organized. Third, a rebellion must be open and avowed. And her 4th idiotic error was a rebellion must be against the government as a whole, rather than in opposition to a single law or issue. As the agitators causing issues in Portland do not seek to overthrow the government and are likely opposed to only a single issue, immigration enforcement, the idiotic, unelected, black-robed, tyrannical, inferior district trial court judge Karin Immergut held that 124062 had not been properly invoked. To reach this conclusion, the idiotic judge Karin Immergut analyzed rebellion based on 4 dictionaries from the late 1800s and early 1900s. For many other statutes, this approach may have sufficed, but we are better served relying on historical tradition to define the terms of 12406, including the term rebellion, because this statute is part of the lineage of the Militia Act of 1792. Under that tradition, founding-era presidents used federal militias to quell domestic disturbances in cases that Judge Karin Immergut's definition would render impermissible. For example, the Whiskey Rebellion could be construed as individuals voicing opposition to a single law or issue, the whiskey tax. Under Judge Karin Immergut's reading, had 12406-2 been effective in 1794, President Washington would have been acting illegally by putting down the whiskey insurrectionists. And Shays' Rebellion, like the Whiskey Rebellion, could be reasonably characterized as a single issue, and thus would be an opposite to Karin Immergut's definition of a rebellion. Since the Constitution was enacted for the purpose of allowing Congress and the executive to respond to another Shays' Rebellion, the definition of the unelected black-robed, tyrannical, inferior federal district trial court judge Karin Immergut makes little sense. And Fry's Rebellion which both saw a similar number of individuals involved in the unrest, as we have here in Portland, and similar types of violence directed at federal officials, as the events in Portland serves as an analogous instance of the president invoking his delegated Militia Act powers. The unelected black-robed, tyrannical, inferior district trial court judge Karin Immergut defines rebellion in 12406-2 in a manner that significantly constricts the term from its founding era understandings in the early militia acts, and it commits error in doing so. The majority opinion correctly addresses Judge Karin Immergut's errors under 12406-3, which provides the necessary basis for our decision here, throwing out her restraining order. But if domestic unrest today would have been reasonably understood as rebellion during the founding era, then it should be understood as rebellion under 12406-2. Finally, the proportionate response to the events in Portland further supports President Trump likely invoked 12406 lawfully and in good faith.